Hello everyone and welcome to this session of Law for All. In today's session, we speak about performer's right under the Copyright Act. What is a performance? Who is a performer? In what circumstances is a performance or a performer granted certain rights, and in what circumstances is a performance protected? Are there any exceptions to this? And in what way is the rights of the performer protected by the Act? Are some of the things that we will look at today. If you all remember, in the last session, we had spoken about cinematograph films. We looked at what is a cinematograph film. We looked at various stages of development of a cinematograph film. We also looked at who has the right in a cinematograph film. So we saw that it is the producer of the cinematograph film who is the author or the first owner under the Copyright Act, which means that the copyright in that work, which is a cinematograph film, vests with the producer of a film. But then if you recollect, we also looked at how many people come together to actually make a film. It is the dialogues written by the dialogue writer. It may be a script written by somebody else. It is the art of the director. It is the manner in which the editing of the movie is done. It is the role or the character which is brought to life by the actor. It is also in Indian cinema, music plays a very important role. It is also the music, the background score of the film. All of these things and much more come together to form the cinematograph film. Similarly, for a sound recording as well, it is not just a sheet music. A sound recording could have the lyrics written by the lyricist. It would have possibly the sound or the music given by the composer, a melody made by the composer. It would have vocals by a singer. The actual music or the melody may be performed by various artists playing various instruments and coming together to form that melody. Are the rights of all these people protected under the Copyright Act? The short answer is there is no copyright granted to anyone other than the producer when it comes to a sound recording or a cinematograph film. But what about others? Do they have any right at all? Until 1994, performers did not have any right in the work which was created. Even today, performers do not have a copyright in the work which is created. Then what is the right of the performer? Mind you, before 1994, there was no right bestowed upon the performer at all. And this led to a piquant situation where composers or singers found themselves at a very disadvantageous position, where after taking a one-time fee, even if the work that they had created was used somewhere else, even if it was used for a purpose other than the film, or even within the film, if the film became extremely successful, they did not get any share in the profits, and the profits were solely the concern of the producer. Prior to 1994, there was no such thing as a performer's right which was granted to actors or singers. Noticing this anomaly, the fact that actors or singers are so important to the actual execution of the work and ultimately to its popularity, this anomaly was noticed by Justice Krishna Iyer in IPRS versus Eastern Motion Pictures, and he observed, strangely enough, author as defined in section 2D in relation to a musical work is only the composer, and section 16 confines copyright to those works which are recognized by the Act. This means that the composer alone has copyright in a musical work. The singer has none. This disentitlement of the musician or group of musical artists to copyright is un-Indian, because the major attraction which lends monetary value to a musical performance is not the music maker so much as the musician. Perhaps Both deserve to be recognized by the copyright law. Another case that is interesting to look at from this point of view is that of Fortune Films International versus Devani. This is a Bombay High Court judgment where the actor had alleged that the producers of the film Darling Darling, the name of the film was Darling Darling, the producers of the film had signed an agreement with him which gave him right or copyright, the word used there was copyright, in the work which he had made in the film. And so long as the payment was not made as per the agreement, if the payment or the fee of the actor was not made to the actor by the producers did not have the copyright. The copyright in the work of the actor belonged to the actor. Now this was a novel phenomenon at that time because the Copyright Act itself did not recognize any such copyright vesting in the actor. The question that had arisen for the court's consideration in this judgment was whether a performance of the actor is a work within the meaning of the Copyright Act as it stood at that time. This is a 1979 judgment. For the performance or for something to be protected under the Copyright Act, it has to essentially fall within the 6 categories of works laid down in the Act itself. What are these 6 categories of work? These are dramatic work, artistic work, it could be a literary work, a musical recording, a sound recording, or a cinematograph film. The argument of the actor in this particular judgment was that the work of the actor will fall into 3 categories, which is the artistic work, a dramatic work, and a cinematograph film. The court negated all these 3 contentions and came to a conclusion that the protection under the Copyright Act as it stood at that time was not extended to the work of an actor or the performance of an actor in a cinematograph film. While holding this, the court held as follows. It would appear to us that the film in its entirety, the mixture or blend in its totality, is protected as also perhaps the small portions of the mixture or blend. The protection, however, is not available to certain components and elements of this mixture, which is the actor's performance, but may be available to the story, screenplay, scenario, or the music in case these satisfy the requirement of a written or similar record. A performer's right is what is called as a neighboring right or a related right. It is not to be confused with a copyright. The copyright is a separate right. Both rights are exclusive, but the copyright is a separate right. A neighboring right or a related right is a right which is ancillary to the copyright in that work. Who is a performer? The Copyright Act defines the word performer. Section 2, subsection QQ of the Copyright Act reads thus. Performer includes an actor, singer, musician, dancer, acrobat, juggler, conjurer, snake charmer, a person delivering a lecture, or any other person who makes a performance. Please note that this is an inclusive definition. So, the categories which are stated here, for example, actor, singer, musician, a snake charmer, or a person delivering a lecture, are not exhaustive in nature. There could be others too, which may fall in the categories, which may fall in the definition of the word performer, so long as it is a person making a performance. Provided that, and there is a proviso, is this protection, or rather is this right recognized for each and every person who has performed in the cinematograph film or a sound recording? Not necessarily. The proviso reads that if the participation of that person is incidental or casual in nature, then that right is not protected. The proviso reads, provided that in a cinematograph film, a person whose performance is casual or incidental in nature and in the normal course of the practice of the industry is not acknowledged, anywhere including in the credits of the film, shall not be treated as a performer except for the purpose of clause B of 38B. Then what is a performance? A performance is also, the word performance is also defined in the Act. Performance in relation to performer's right means any visual or acoustic presentation made live by one or more performers. So what this includes is live music shows, a circus performance, lectures which are delivered, and the list is quite long. The exclusive right that a performer has is given in Section 38A of the Copyright Act. Section 38A was inserted by the 2012 amendment to the Copyright Act. What is this right? The right that the performer has is a right to make a sound recording or a visual recording of his or her own performance, and then to communicate it to the public, make copies of that recording, to broadcast it, give it on rental, and so on. Subsection 2 states that once a performer has, by a written agreement, given his consent to the incorporation of his or her own performance in a cinematograph film, then the performer shall not object, unless there is any contract to the contrary, to the enjoyment by the producer of the film of the performer's right in that film. One important provision is the proviso to subsection 2, which states that notwithstanding anything contained in this subsection, that is subsection 2, the performer shall be entitled to the enjoyment of royalties in case of making of performances for commercial use. Another important addition by the 2012 amendment is Section 38B, which is moral rights. For the first time, performers are given moral rights on their performance. Until now, it was only the moral right which was the author of any of the works mentioned earlier which was protected, but not that of the performer. The performer had no right and no control over the manner in which the performance was used once it was incorporated or once his right was assigned to another. There are two moral rights which are given in Section 38B. One is to get credit for the performance, to claim to be identified as the performer of his performance except where omission is dictated by the manner of the use of the performance. And second is to restrain or claim damage in respect of any distortion, mutilation or other modification of his performance that would be prejudicial to his reputation. Are there any exceptions to the performer's right? We saw that under Section 38A, the performers has certain exclusive right, like making a recording and communicating it. Secondly, also some moral rights under 38B. Section 39 lays down exceptions to the performer's right. In certain circumstances, the work may be recorded and may be used by another. What are these circumstances? First is recording by a person for private use, whether it is a sound recording or a video recording, and use for research and for teaching. Second is use of an excerpt or a part of a performance for the purpose of review or reporting of current events. And thirdly, doing such acts as laid down in Section 52, that is certain acts which do not constitute infringement of the author of the copyright or the right of the author in the work, with certain modifications as may be suitable for the performers. The 1994 amendments and the 2012 amendment to the Copyright Act are attributable partly to the developments in the international sphere on this aspect. The first notable convention is the Rome Convention on the Protection of Performers, Producers of Phonograms and Broadcasting Organizations of 1961. Then comes the Trade-Related Intellectual Property Rights, that is the TRIPS Agreement. Then the World Performances and Phonograms Treaty in the 1990s and the WIPO Copyright Treaty. All of these developments contributed to the enactment of the 1994 as well as the 2012 amendments. While the 1994 amendment as well as the 2012 amendment has made various provisions for the performers' rights and the protection of performers' rights, the challenge lies in enforcement of these rights. There are copyright societies which are formed in order to ensure protection and in order to ensure that royalties are given to the performers in these works. However, ensuring that the royalty is paid in every scenario and it is actually goes to the performer is the challenge that lies ahead. Thank you.